Hello, my name's Marcia Longdon. I'm one of the partners in the immigration team, and I'm here with my colleague
Andreas White, and I'm one of the partners in our employment team here at Kingsley Napley.
Thanks, Andreas. Thank you so much for indulging me. I say indulging me, but it's really indulging clients. We've had lots of questions about the recent developments with the UK visas and immigration. Just a very quick summary to set the scene of what we're going to talk about this afternoon. On the 4th of April 2024, obviously, the UK government increased the minimum salary for skilled workers to 38,700. Now, there are some circumstances whereby if you're a new entrant, the salary will be different, but I'm not going to sort of talk about that today. I really want to explore the impact of the new salary increase on employers. And so from the 4th of April, that's a salary that you've got to pay, almost like regardless of what the role is. So my question, or the question that we've had from employers, is what happens to those who before the 4th of April were being paid, for example, 26,200. They were being sponsored for exactly the same job, and also if they are a British national or they are a settled worker in the UK, but they're not getting paid the 38,700, which is a new rate. Can you tell me your thoughts from an employment law perspective, or just practically too?
Sure. Well, I think, from an employment law perspective, the first question is always, what are the contractual rights? What do the employment contracts say? And realistically, I don't think there's any chance that anyone would have a right under their contract now to get a pay rise to bring them in line with the new hire who was under the new the new immigration rules. You'll have to do an annual pay review, and that's discretionary. So pay would be reviewed in due course, but it's not going to result in an impact on those currently in the job under the old rules or who didn't need a visa. The practical issue though is they're going to be unhappy, I think employers would be well advised to take the temperature, and if they do receive written complaints, then they'd need to use their grievance procedure to consider them. There's an impact on or a potential impact on morale, productivity, and you can see how it seems pretty unfair, and so you could have aggrieved employees, and that's never a good thing.
So Andreas, bear with me when I say the next thing, right? Because obviously we're not employment lawyers, but we've had clients sort of say to us, isn't this discrimination because we're paying somebody differently who's doing exactly the same job?
Yes, and I think that's a good example of how in the workforce day to day, in everyday life, the way in which people use the phrase discrimination is different to how employment lawyers and employment judges consider that term, because that's under the Equality Act. And often in everyday life, when people say I feel discriminated against, what they mean is that they feel unfairly treated, arbitrarily treated. And as I said, you're going to have a risk of disgruntled employees or aggrieved employees, and you might have to manage that pretty carefully, including possibly under your grievance procedure. But whether they actually have been discriminated against in a legal sense under the Equality Act, I think is very much open to debate. And personally, I don't think it is. I don't think it is race discrimination under the Equality Act. The question you have to then ask yourself, if you're looking at a race discrimination claim, is what was the reason why someone was treated? They were treated in the way that they were. And in this case, the reason why is the government rules that have been introduced that employers have got to follow. And I don't think those who are in the job under the old rules, with a visa under the old rules, or who are in the job and didn't need a visa in the first place, if they're now being paid less than someone who's a new hire and falls under the new rules, skilled worker visa rules, then as I say, I think that the reason why is not actually there nationality, it's not because of their race. So I don't think it is direct discrimination.
I think that's a good point then. So what you're actually saying is that, like you say, there was no choice because the government implemented this thing from the 4th of April. So you've got to obviously obey what the government says from an immigration perspective. So that's why you're doing that. Okay, we have that answered. Thank you very much. The other question I sort of wanted to put to you, which is more recent, was that you have the shortage occupation list, which has roles on that list which are in shortage in the UK. There's nobody who could do them, right? So certain jobs are put on this list, which means that employers actively have to seek cover or go overseas to have people to fill those roles. So what the government said was, okay, well, if you're doing a job that was on the shortage occupation list before the 4th of April, obviously you're sponsored, and then you're going to come up for extension post 4th of April, we would offer, i.e. the government would offer, a 20% increase to those salaries, okay? If you're going to be with the same employer, right, and do the same job, and you come up for extension, but those jobs are no longer on what's now called the immigration salary list, right? They still said just 20%. But since the rules have been published, they've now reneged on that and said, well, okay, we don't kind of care. You're going to have to pay the 38,700. So in a real life example, you've got someone being paid 26,200. Let's say they're coming up for extension in July. The employer would have to pay them the minimum salary of 38,700. I clearly have my views on that, but do you have any comments that think could impact employers, or how do you think they would react to something like that?
I think it sounds like another example of, well, the rules are the rules and you've got to follow the immigration rules, frustrating as it's going to be for a lot of employers. But I guess the other thing is, there are going to probably be cases where employers are actually then asking themselves, well, is this economic anymore? Because we're now being forced into a situation where we've got to apply this arbitrary large increase, and maybe these are in lower skilled, less highly paid jobs, and if there's no longer a shortage of that workforce in the UK, then maybe employers will think, well, actually we could hire someone without a visa at a lower price, and so there might be situations where they're then thinking, do we even want to renew the visa? Do we even want to carry on this employment relationship? But
I'm going to slightly digress, and it's slightly naughty of me, and I won't say which company it was, but one of the big four in the last couple of weeks had to withdraw offers that they had made to their graduates because they were not able to pay the 38,700. They paid their graduates a much lower salary. And that's public knowledge, it was in the press, so I'm not, so just to echo exactly what you're saying, you might say lower skilled, but that was, a very large accountancy firm.
Sure.
Right? So that's, a very, high level, it's a skilled role. So the point I think I'm trying to make is that it's impacting everybody. But anyway, you'll be pleased to know we're coming towards the end. Can I ask you, do you think, have you got any advice for employers in light of everything that's happening? Is there anything that you need to remind them of?
I think, as you've said, you're going to have cases now where some employers are actually asking themselves, do we actually want to carry on hiring skilled workers, needing visas, and with all of the costs that are involved? And there was a case quite a few years ago now where a law firm came unstuck when they had a policy that they only accepted applications for people who didn't need a visa, who already had the right to work in the UK. That was in the days of free movement and the EU, so a bigger pool available. But they were found to have committed indirect discrimination when their application portal did not allow people to progress through the application process if at the beginning they indicated that they didn't already have the right to work in the UK. And as I say, that was indirect discrimination, and you can see a situation now, and we're hearing it on the grapevine, that some employers might again be thinking, well, maybe from now on we just don't accept applications from people who would need a visa, who don't already have the lawful right to work in the UK. And there's a provision in the EHRC Code of Practice that says all applications should be considered purely on merit, and you should just look at the skills and experience of the candidate for the job, and then you should always consider, do your right to work checks and consider whether someone already has the right to work or whether they might need a visa later on in the process. So our advice would remain unchanged. Don't have a universal blanket policy not to accept applications from people who don't already have the right to work in the UK and would need a visa.
Yeah. So just one or two final comments in relation to the skill level and the shortage occupation codes. I know that we are discussing things with the policy team at the UKVI to say to them that they need to rethink that particular clause in the guidance. But I think really as well, in summary, after having spoken to you, really employers should just review at the appropriate time, isn't it? Salaries being paid, and if they can match them, they can match them. But just make sure that they don't do anything that would cause them issues in the long term to try and have a happy workforce, isn't it?
And that's always a good thing, yeah.
Brilliant. Thank you so much, Andreas, and thank you.